The hip-hop community was shaken in October 2018. Rising star YNW Melly, known for his hit "Murder on My Mind," was implicated in a double homicide. The victims were his close friends, Anthony YNW Sackchaser Williams and Christopher YNW Juvie Thomas Jr. Initially, their associate Cortland YNW Bortland Henry claimed a drive-by shooting. But the story unraveled. Inconsistencies in Henry's account, coupled with other evidence, led authorities to suspect Melly's involvement. In February 2019, Melly was arrested and charged with 2 counts of first-degree murder. The charges against Melly sent shockwaves through the music world. His haunting track, "Murder on My Mind," became tragically prophetic. Streaming numbers surged, a grim reflection of the public's fascination with the case. Melly maintained his innocence, but the evidence against him seemed substantial. The prosecution alleged that Melly, along with Henry, had orchestrated the murders, attempting to stage them as a drive-by. As the legal proceedings began, the case became a focal point, raising questions about gang violence, the pressures of fame, and the complexities of justice. The trial promised to be a media spectacle, with fans and critics alike eager for answers. However, the legal process was just beginning, and the road to justice would be long and arduous. Melly's fate hung in the balance, his life transformed from rising star to accused killer. The world watched as the legal drama unfolded, waiting to see if the lyrics of "Murder on My Mind" would become a horrifying reality in a courtroom. Florida's death penalty laws have long been a subject of intense debate. The state has a grim history as one of the most active practitioners of capital punishment in the United States. In recent years, however, there's been a shift in the legal landscape, fueled by high-profile cases and growing concerns about fairness and justice. The case of Nicholas Cruz, the Parkland school shooter, brought these issues to the forefront. In 2022, a split jury spared Cruz's life, sparking outrage and calls for reform from those who believe he deserved the death penalty. Governor Ron DeSantis, responding to the outcry, signed a bill in 2023 that significantly altered Florida's death penalty statute. The new law lowered the threshold for a death sentence from a unanimous jury decision to an 8-4 vote. This change, lauded by some as a necessary measure to ensure accountability, drew sharp criticism from others. Opponents argued that it undermines the sanctity of a unanimous verdict, increasing the likelihood of irreversible errors in capital cases. The debate over the law's constitutionality and moral implications intensified, further polarizing public opinion on the death penalty in Florida. The impact of the new law was immediate and far-reaching. Non-unanimous death sentences in Florida surged, accounting for over a third of such sentences nationwide in 2024. This surge raised alarm bells for human rights advocates who pointed to the inherent racial bias in the criminal justice system. Studies revealed that defendants of color were disproportionately more likely to be sentenced to death by non-unanimous juries, particularly in counties with a history of racial disparities in prosecutions. Florida's death row, once a symbol of justice for some, became a flashpoint in the national conversation about race, justice, and the Eighth Amendment's prohibition against cruel and unusual punishment. The debate over Florida's death penalty laws goes beyond the specifics of individual cases. It strikes at the heart of fundamental questions about fairness, justice, and the very nature of a democracy. The shift towards non-unanimous jury decisions for capital punishment has reignited long-standing concerns about racial bias in the criminal justice system. Critics argue that this change disproportionately impacts defendants of color, who are statistically more likely to face juries with fewer people of their own race or ethnicity. This lack of representation, they argue, increases the risk of implicit bias influencing jury deliberations, potentially leading to unfair and racially skewed outcomes. The constitutionality of non-unanimous jury verdicts in death penalty cases has been a subject of intense legal scrutiny. The Sixth Amendment guarantees the right to a fair trial by an impartial jury, and the 14th Amendment ensures equal protection under the law. Opponents of non-unanimous juries argue that these constitutional rights are violated when a defendant's life can be taken without the full agreement of the jury. They point to the historical roots of non-unanimous juries in Jim Crow-era laws designed to disenfranchise black citizens and maintain racial hierarchies within the legal system. The American Civil Liberties Union, or ACLU, has filed lawsuits challenging the constitutionality of non-unanimous jury verdicts in Florida, particularly in Duval County, where racial disparities in death penalty cases are particularly stark. The legal battles over Florida's death penalty laws are playing out against the backdrop of a national reckoning on race and justice. The Black Lives Matter movement has brought renewed attention to systemic racism within the criminal justice system, prompting calls for reform at all levels. The debate over the death penalty in Florida is inextricably linked to these broader conversations about equity, fairness, and the need for a system that values the lives and rights of all citizens equally. As legal challenges to Florida's death penalty laws make their way through the courts, the nation watches, grappling with complex questions about justice, race, and the purpose of punishment in a civilized society. The YNW Melly case has become a potent symbol of the complexities and controversies surrounding Florida's death penalty. Charged with the double murder of his friends, Melly faced a potential death sentence if convicted. His first trial in July 2023 ended in a mistrial, with the jury split 9-3 in favor of conviction. The mistrial offered a brief respite for Melly, but it also highlighted the high stakes involved and the difficulties of securing a unanimous verdict in a case that had captivated the nation. Controversy erupted following the mistrial when allegations of prosecutorial misconduct surfaced. The lead prosecutor was accused of withholding evidence and making improper statements to the jury, prompting a judicial inquiry. In October 2023, the lead prosecutor was removed from the case, casting a shadow over the integrity of the prosecution's case. Melly's defense team seized on these missteps, arguing that they demonstrated a pattern of misconduct and a disregard for due process. A new prosecutor was appointed, and the retrial was scheduled for September 25, 2025, prolonging Melly's legal ordeal and adding another layer of complexity to an already high-profile case. As Melly awaited his retrial, his legal team mounted a separate battle, this time challenging the conditions of his confinement. In November 2024, Melly filed a lawsuit alleging that he was being subjected to cruel and unusual punishment at the Broward County Jail. The lawsuit claimed that Melly had endured prolonged solitary confinement, severe restrictions on communication with his family and legal team, and limited access to basic necessities. These harsh conditions, his lawyers argued, violated his constitutional rights and amounted to psychological torture. Melly's lawsuit shone a spotlight on the often overlooked issue of inhumane jail conditions, further fueling the debate about the fairness and humanity of the criminal justice system.